Hello, I'm attorney Bob Babcock from the law firm Tully Rinckey. Today I'd like to talk to you about suppression of evidence in criminal cases. There are three types of evidence in criminal cases that are subject to suppression. Number one is physical evidence. Evidence such as a gun or a weapon, stolen goods, or a half-empty bottle of liquor in a DWI case, or forensic evidence such as blood, hair and fibers, or other sources of DNA. These are all types of physical evidence that are subject to suppression if they are unlawfully seized by police. If your criminal lawyer believes that the evidence in your case against you was seized improperly or against the law or regulations, they may move for suppression and they will request what's called a MAP hearing. The court will allow both sides' attorneys to appear for the MAP hearing to make arguments about the admissibility of that physical evidence in your case at trial. If the court should rule that physical evidence was taken improperly, the court would preclude the government from admitting that evidence against you at your trial. The second type of evidence that is subject to suppression is statement evidence. If you have statements you've made to the police while in custody, pursuant to questioning by the police, those statements can be subject to suppression. Again, your criminal defense attorney, if he or she believes that those statements were taken from you improperly, will move to suppress those statements. They will request what's called a Huntley hearing. And again, the court will allow attorneys for both sides to appear before the court and make arguments about the admissibility of those statements against you at trial. The third type of evidence is identification evidence. Identification procedures of a client are subject to suppression. So, if your identification was made by police through a lineup or through a photo array or any other type of identification process that doesn't follow proper procedures, those identification procedures may also be subject to suppression. Now again, as a reminder, if evidence is suppressed in a criminal case, it does not mean that that case is dismissed. It simply means that the prosecution cannot use that piece of evidence against you in their case at trial. Thank you.